Good morning, everybody, or afternoon, depending on where you're at. I'm in California, and boy, has it been hot in the Bay Area, 100 degrees, so uncommon. Today, we're going to talk about the Pregnancy Workers Fairness Act and how it might interact with some of your other regulations, like the Family Medical Leave Act. And of course, the Pregnancy Workers Fairness Act is an ADA regulation. It's a work regulation. However, it allows for leave if it's not an undue hardship, if you're unable to provide an accommodation at work. And when you're talking about leave under Pregnancy Workers Fairness Act, it doesn't necessarily mean that it meets the criteria of a serious medical condition under the Family Medical Leave Act. But certainly if it does, and it would be a medical provider who would confirm that, or simply with a CFR form if you're in California, you've got locked down with the questions you can ask on those CFR forms. And if they are telling you that this meets the criteria of a serious medical condition for their pregnant female, then you're going to be running these FMLA regulations concurrently to Pregnancy Workers Fairness Act. But make sure you're really clear about what the requirements for eligibility are for the different regulations. And when you've got state regulations, and many of you do, that address these issues, you're going to want to make sure that those are also separated if, in fact, they could or could not run concurrent based on the eligibility requirement itself. So let's just talk about Pregnancy Workers Fairness Act. I'll be looking off the screen a little bit because we've created a set of slides for you to follow along with. And so that's what we'll be talking about. So let's start with slide 1. What is the Pregnancy Workers Fairness Act? The Pregnancy Workers Fairness Act went into effect 2023, and if you've got 15 or more employees, you are now required to provide a reasonable accommodation to a known limitation related to a pregnancy, childbirth, related medical condition, unless the accommodation will cause an undue hardship. This is very important, everybody. There's 2 things. First, we don't mess with pregnant women. We protect them if we can do that, and it's our intent to make sure that we do. But it also needs to not be an undue hardship because this is still an ADA regulation. And if you're not familiar with what it takes for it to be an undue hardship, that is a completely separate analysis. It's done either past or before or throughout the good faith interactive process. Once you've determined there's a request that's being made, that there is potentially imminent harm to self or others, or there's an impact to the organization that is significant. So when we're looking at undue hardship, we're looking at a very specific process. We do separate trainings on those. You can download them on the internet. They're on our website. But this is a high overview of what the requirements are. So yes, if it's not an undue hardship, you are accommodating the pregnant female at work under the Pregnancy Workers Fairness Act. So what are the factors that you're determining if an undue hardship exists? Well, the next slide talks about the undue hardship itself, the high-level criteria. But the way you document this and the way you analyze this is going to be very important. So the financial resources of the covered entity regarding the number of persons employed, the effect on the expenses and resources, and the overall size of the business with respect to the number of its employees and the number, type, and location of its facilities. And we're getting this right out of the regulation, everybody. That's a lot of information, but really that means you're opening your books up to show why it would be too expensive to hire another person to help or a temporary worker to step in, or all the other modifications you might make to the production process for people who have assistance that is needed when they're pregnant. That's what we're going to be looking at, is those kinds of things. Are we going to be creating brand new rooms for $250,000? No. Are we going to be creating new rooms for $25,000? Probably not. But at some point, there's going to be a comparison of why those numbers mean something if we're using financial burden as the reason for the undue hardship. The next issue is composite structure and functions of the workforce of the entity and the geographic separation and administration of the fiscal responsibilities of the facility or the facilities in question to be covered to the covered entity. And again, I'm stumbling over the words a little bit. You can read it yourself. But this is right out of the regulation. So what this is saying, in my experience, is if you are impacted in the operations, if you are miles and miles apart when you're trying to replace somebody who needs to take a break, these are the processes that we go through in organizations to get our work done and to meet our customers and our clients' needs. So if those are impacted significantly, it could also be an undue hardship. But again, these are very generic descriptions, and the issue is going to be, and what's going to be important is the way that you document and analyze the primary data you're using to come to some of these conclusions. And I could say, just as a side note, with my experience with the expert testimony environment, is we're looking at clear, objective data, everybody. This is not someone's opinion. This is something we can verify. And the last is impact of the accommodation upon the operation of the facility itself, including the impact of the ability of the other employees to perform their duties and the impact on the facility's ability to conduct business. Again, a very big statement, but that's where undue hardship comes from. It is not somebody's opinion. The line got shut down. The customer was not able to meet their delivery date. These are the things that would be what we're looking at for undue hardship. So moving on, then we're going to the next slide. The EEO states that an individual may be considered a qualified individual with a disability under the Pregnancy Workers Fairness Act only, everybody, under the ADA, even if they cannot perform all the essential functions of the job. This is the big differentiator. When you are impacted by pregnancy, we don't expect you to be able to do all the functions of the job at a meets expectations level. We are going to help you on site perform all the functions that you can perform with your pregnancy or the challenge that you're having. That's the goal. And if for some reason we can't do that because you can't perform all the functions, maybe you're exposed to a chemical or it's too dangerous, it's an uneven environment, many different reasons, then that's when we would be looking at leave under the Pregnancy Workers Fairness Act as an accommodation. So ADA is a work regulation. So is Pregnancy Workers Fairness Act. We want our employees to be able to work. And anything that we can do with them there, we're going to help them achieve, if it's not an undue hardship. But if we find that it is, the portions of their position they can't perform, we'll be wanting to provide them leave. Providing the leave also needs to not be an undue hardship. So what does it say? If their ability to perform the essential functions is temporary and could be resolved in the near future, approximately 40 weeks, which is, of course, the length of a pregnancy, and the accommodation does not create an undue hardship, the employer must accommodate the employee. The Commission also interprets the Pregnancy Workers Fairness Act to require employers to provide accommodations for temporary pre-pregnancy limitations, such as challenges with fertility, and post-pregnancy limitations, such as unforeseen health problems arising from the pregnancy. And of course, some of that's going to start crossing over to the ADA if it is exhausted the Pregnancy Workers Fairness Act 40 weeks. So you're going to be very much looking at whether the ADA applies if for some reason Pregnancy Workers Fairness Act gets exhausted. So on the next slide, we're talking about the accommodations under the Pregnancy Workers Fairness Act are expected to be provided in virtually all circumstances without medical documentation. That's the stuff that you expect them to need. Now, if they're asking you to lie down and take a nap every 20 minutes, every hour, I'm going to be asking for medical documentation to understand why that kind of an accommodation is necessary, and we may or may not be able to help them with that. But the underlying issue is women who are pregnant, we have very standardized expectations of needs, and the women who are pregnant have pretty standardized expectations of needs, and the expectation is that the employer understands that, is going to simply assist the pregnant woman. We don't mess with pregnant ladies anymore, everybody. Let's help everybody. It goes on to say that documentation is not necessary for those accommodations that the EEOC has identified as predictable assessments. So let's go and talk about what that is. So on the next slide, what is it? The ability to sit and take a break, to have water or ability to have something to drink that is close when you need it. Have parking that is closer if you're having to walk a long distance. Have flexible work hours if it works with the operations of the organization. Maybe you come in a little later because you have challenges with morning sickness. You receive appropriately sized uniforms and safety apparel, the same number of uniforms they would receive as a new hire for whatever size as they move through their pregnancy. Receive additional break time to use the bathroom and eat and rest. Now, additional break time doesn't mean that it's paid, everybody. It just means that if they need more time to take breaks during the workday and still be able to perform their job, let's do that if we can. And be excused from strenuous activities and or activities that involve exposure to compounds that are not safe for the pregnancy. So employers are required to provide reasonable accommodations unless they would cause an undue hardship on the organization. And we've talked about what that means. And that's a bigger bite than a lot of people are aware of. Many attorneys say there are no undue hardships, and we simply know that that's not accurate. But the way that we document and the way that we analyze and the way we determine why it is matters. Don't ever forget to go to Ask Jan before you ever come to a conclusion that something is an undue hardship without getting clear, without getting additional resources that you might be able to answer these questions for you. And then the other thing is, open your mind. Ask the women in the environment how they think it could work for them. You'd be surprised at the creativity of your own employees to solve some of these challenges themselves, and maybe it would work better for everybody. You never know. It is unlawful for employers to not engage in the interactive process. Well, let's say that a different way. You are not complying with the Pregnancy Workers Fairness Act or the American with Disabilities Act, by the way, if you don't engage in the interactive process. What makes it unlawful is if your employee decides to sue you, then you may have a lawsuit on your hands. But our job in HR is to make sure we understand how to comply with these regulations in our organizations, in our culture, with our employee base that we know. We need to engage in the interactive process as soon as we know or should have known somebody needs assistance because of a pregnancy or any other medical issue, by the way. We do not deny employment opportunities to employees based on their need for an accommodation, even if they can't perform all the essential functions of the job under the Pregnancy Workers Fairness Act. Very, very clear distinction. We cannot require the employee to take leave, whether paid or unpaid, if we have a way to accommodate them on site. We can only offer leave as an accommodation under Pregnancy Workers Fairness Act if we have determined we cannot accommodate any part of their job they can do, because they don't have to be able to do all of their job when they're pregnant. If they can just do a couple hours a day, we want them there for a couple hours a day and let them be there, and then we accommodate with leave for the rest of the time. And we take adverse action in terms of conditions or privileges of employment against a pregnant employee? No more than we would for somebody who is protected under the ADA. So what's our checklist? We don't ask for medical information unless it's unreasonable. The request on its face, it does not make sense based on the list that we already have and things that you would expect for a pregnant woman to need. Get clarification from LMS. Give us a call if you think you need to get medical certification and you're not clear why you should or you shouldn't. Let us help you. But always document. Get your checklist out and make sure you're going through the interactive process with Pregnancy Workers Fairness Act if it's anything more than the reasonable accommodations request that you would expect them to need. If it's a reasonable accommodation request that you would expect them to need, help them immediately. And then Remember, last slide, employers are required to prevent discrimination against employees because of their pregnancy. So let's make sure that the workforce understands that we're there to help, but also that does not mean that we are taking advantage of other employees and making them step in when they are being impacted. So it's an approach. There's lots of different things that we're trying to do to build families in organizations and reach out to other areas where we can help families build families when they are not just a traditional male and female or a female having a child. And some of you are reaching out to some of those other opportunities in providing benefits to your employees that are family-friendly benefits way beyond the state and federal regulations. We've got a Facebook page that we've started talking about that a little bit because we see that be a trend in a positive direction. So join us. Let us know how we can help. Bye.